I'm going to wait for my ranking member to get here. He was here, he just stepped out, so just relax. We're going to call the hearing back to order. This is a continuation of the hearings that started last week. And so on the second panel, we have Mr. David Bearden, who's a specialist in environmental policy from the Congressional Research Service, and also joined by Mr. David Trimble, who's the Director of the National Resources and Environment from the Government Accounting Office. Gentlemen, your full statements has already been submitted for the record. You have 5 minutes. As you can see, I don't think we're really pressed for anything immediately, so we'll be generous. It's really, I guess, us a chance to understand this program more and ask follow-up questions. So with that, I'd like to recognize Mr. Bearden for 5 minutes. And let's make sure the mic's on and it gets pulled close to you. No, there's a button. There should be. Is it green?
It's now green.
Okay, pull it a little bit closer.
Okay, thank you, sir. Chairman Shemkus, Ranking Member Tonko, and members of the subcommittee, my name is David Bearden, and I'm a specialist in environmental policy for the Congressional Research Service. Thank you for inviting me to testify on behalf of CRS on legislation that would amend the Comprehensive Environmental Response, Compensation, and Liability Act to address various aspects of the federal and state roles in the cleanup of environmental contamination and the applicability of state cleanup requirements at both current and former federal facilities. In brief, the primary areas that the legislation would address include the designation of sites on the national priorities list, credits towards state matching funds requirements at non-federal facilities, the selection of cleanup actions and opportunities for judicial review of such actions, the establishment of financial responsibility requirements, and the waiver of sovereign immunity at both current and former federal facilities. In serving the U.S. Congress on a nonpartisan and objective basis, CRS takes no position on this legislation, but has been asked by the subcommittee to identify the federal and state roles under CERCLA in existing law and the aspects of these roles that the legislation would address. The statements presented in this testimony are based on a preliminary analysis of the legislation within the time available. CRS remains available to assist the subcommittee in its consideration of this legislation, related issues, and potential concerns among affected stakeholders. I'll now just provide a brief summary of the existing framework of federal and state roles under CERCLA, and then a summary of the main provisions of all 3 bills. Congress enacted CERCLA in 1980 and the 96th Congress in response to a growing desire for the federal government to pursue the cleanup of the nation's most hazardous sites to protect human health and the environment. Under the Superfund program, the Environmental Protection Agency, EPA, may pursue cleanup and enforcement actions to respond to actual or threatened releases of hazardous substances into the environment. CERCLA established a broad liability scheme that holds past and current owners and operators of facilities, generators of waste, and transporters of waste who selected a facility for disposal liable for cleanup costs, natural resource damages, and the cost of federal health, public health studies that are conducted by the Agency for Toxic Substances and Disease Registry. In conjunction with this liability scheme, CERCLA directs EPA to establish requirements for private entities to demonstrate their financial capability to satisfy cleanup liability if contamination were to occur, but EPA has not yet promulgated such requirements. The Superfund Amendments and Reauthorization Act of 1986 in the 99th Congress amended CERCLA to address the applicability of the statute and state law to federal facilities and amended various cleanup, liability, and enforcement provisions of the statute. Several subsequent laws also have amended CERCLA for specific purposes. With respect to federal and state roles, which is the primary area of focus of the 3 bills, the Small Business Liability Relief and Brownfields Revitalization Act of 2002, enacted in the 107th Congress, amended CERCLA to authorize federal grants to states and local governments for the cleanup of brownfield sites that are not addressed under the Superfund program, to give substantial deference to the states and EPA's designation of sites on the national priorities list, and to limit the use of federal enforcement authorities under CERCLA to pursue the cleanup of a site if a state is already pursuing the cleanup under its own law. CERCLA directs EPA to maintain the national priorities list to prioritize sites for federal response actions. Under CERCLA, federal response actions may include interim removal actions, as they're called, to address more immediate risks, and broader remedial actions to address long-term risks. Remedial actions also differ in that the use of federal Superfund appropriations is conditional upon the state agreeing to share the cost with the federal government, whereas removal actions may be fully federally funded with Superfund appropriations. Under federal regulation, a site also must be on the national priorities list as an additional condition for EPA's use of federal Superfund appropriations to finance the remedial actions. The cleanup of Superfund sites that are financed with private funds from the potentially responsible parties are not subject to this condition and therefore do not necessarily require listing on the NPL to perform the remedial actions that are not funded with federal tax dollars. EPA may fund removal actions with federal Superfund appropriations to address immediate hazards regardless of whether a site is on the national priorities list. The response authorities of CERCLA are also available to federal agencies for the performance of the cleanup of federal facilities that are funded with separate appropriations apart from Superfund, and these separate appropriations are allocated directly to the agencies that administer those facilities. The Department of Defense and the Department of Energy administer the vast majority of federal facilities where cleanup is performed under the authorities of CERCLA and other relevant statutes. EPA and the states still play a role, however, in overseeing and enforcing the cleanup of federal facilities. EPA leads the oversight of the cleanup of federal facilities that are on the national priorities list, but still in conjunction with the states. And the states primarily are responsible for leading the oversight of the cleanup of federal facilities that are not on the national priorities list, where EPA does not have a similarly prominent role. CERCLA authorizes various mechanisms for the states and the public to participate in federal cleanup decisions. However, EPA or the lead federal agency at a federal facility generally is responsible for making the federal decision. Those decisions, though, still may involve the application of state cleanup requirements if they may be more stringent than the federal requirement. CERCLA authorizes citizen suits, including suits by states, to challenge federal decisions regarding response actions, both remedial and removal, but limits the timing of judicial review until after the action is taken. CERCLA also specifically authorizes states to bring action in U.S. District Court to challenge the selection of remedial actions at a federal facility within its borders. Conditions for the use of federal Superfund appropriations can also be a factor in cleanup decisions that are made in consultations with the states at non-federal facilities. The use of federal Superfund appropriations to finance remedial actions is generally conditional upon the state agreeing to pay 10% of the capital cost, with the federal government paying 90%, and generally 100% of the cost of long-term operation and maintenance in maintaining any institutional controls that might be necessary over the long term. There is an exception for the treatment of groundwater, under which the federal government may pay the full cost of operation and maintenance for the first 10 years of the remedy, after which point the state would assume its responsibility for the 100% cost of the operation and maintenance. These state matching funds requirements do not apply to the use of federal Superfund appropriations for removal actions, nor to either remedial or removal actions that are carried out at federal facilities and funded fully by the federal government separately with appropriations to those agencies that administer those facilities. The legislation that's before the committee, the three bills collectively, would expand the role of the states in the cleanup of contaminated sites under CERCLA beyond the scope of the most recent amendments I mentioned earlier that were enacted in 2002 in the 107th Congress. The following points that I've outlined briefly identify how each bill would alter the state role in comparison to existing law. The first bill, the Federal and State Partnership for Environmental Protection Act of 2013, would do the following, make the following changes to existing law. It would expand consultation with affected states to include not only remedial actions, but also removal actions. including consultation with state and local officials at federal facilities. Another provision would expand the categories of non-federal funds that states could apply as credits towards meeting matching funds requirements to include state oversight costs and in-kind expenditures. In-kind expenditures essentially are non-monetary contributions that may offset some of the costs. Another provision would codify in statute EPA's general practice of obtaining the concurrence of the governor of the state in which the site is located in making a decision to list a site on the national priorities list, and would give greater deference to state priorities in the listing process overall. It would also broaden the opportunity for judicial review of a remedial action if a state were to object to the selection of a remedial action in writing. The next bill, the Reducing Excessive Deadline Obligations Act of 2013, has two primary provisions. The first provision would bar federal financial responsibility requirements that EPA may promulgate in the future from preempting state financial responsibility requirements that are in place on the effective date of any federal requirements that EPA may promulgate. The other provision is related to the Solid Waste Disposal Act and not CERCLA, and it would amend the Solid Waste Disposal Act to require EPA to review and revise regulations promulgated under that statute as determined appropriate by the agency, rather than under existing law requiring review and revision as necessary every 3 years. The last bill, the Federal Facility Accountability Act of 2013, as its title suggests, would focus on federal facilities, and in two respects would expand the waiver of sovereign immunity at federal facilities to include not only current, but also former federal facilities, to encompass the entire phase of the cleanup process for both remedial and removal actions, and to clarify the extent to which substantive and procedural requirements of state law apply to federal facilities, regardless of whether a facility is on the NPL, the National Priorities List. The other respect of the bill would authorize EPA to review the actions taken by other federal departments and agencies under CERCLA at federal facilities, regardless of whether a facility is on the National Priorities List, and also would allow states to request such a review by EPA to ensure consistency with EPA guidelines, rules, regulations, or criteria. That concludes the remarks of my prepared statement, and thank you for the opportunity to appear before the subcommittee today, and I would be happy to address any questions you may have.
Thank you, Mr. Bearden. And now I'd like to recognize Mr. David Trimble, who's from the Government Accountability Officer. You're welcome. Same thing, full statements in the record. You have 5 minutes. Obviously, I was very generous because we're here to get a good background on these policies and pieces of legislation. So you're recognized.
Thank you. Chairman Shimkus, Ranking Member Tonko, and members of the subcommittee. My testimony today focuses on GAO's work on 4 key issues: the role of the states in cleaning up hazardous waste sites, federal liabilities and management of sites listed on the NPL, the National Priorities List, commonly referred to as Superfund sites, the challenges and liabilities associated with contaminated hard rock mining operations, and litigation under environmental statutes, including CERCLA, the statute governing the Superfund program. First, states play a critical role in cleaning up sites listed on the NPL and severely contaminated sites that are not listed on the NPL. After a hazardous site is identified by EPA, often working with a state, will evaluate the risks to the environment and to human health and assign a hazard ranking score. Sites posing hazards above a certain threshold are eligible for listing on the NPL. Not all sites with serious contamination and a high score are placed on the NPL, and EPA policy is to not list such sites without approval from the relevant state. Additionally, EPA cannot use money from Superfund for long-term remediation activities unless the state has also agreed to pay at least 10% of these costs. The cleanup of sites not on the NPL can be managed by EPA as a Superfund alternative site or by the states and other entities under other cleanup authorities. In April, we reported that 42% of sites assessed with contamination severe enough to be eligible for listing on the NPL were being managed as Superfund sites or Superfund alternative sites. The remaining 58% were managed by other cleanup programs. Notably, states managed the cleanup of more Superfund caliber waste sites outside of the Superfund program than EPA oversees in the Superfund program. Second, federal agencies, primarily DoD, have substantial cleanup and financial liabilities at NPL sites. Specifically, DoD is responsible for 80% of the 156 federal Superfund sites. The cost to clean up these sites represents a significant financial liability for the government. In addition, in 2010, we found that DoD's refusal to sign a required interagency agreements with the EPA on how these cleanups should proceed had complicated cleanup at 11 DoD NPL sites. As a result of our work, DoD has decreased this number to 2 sites. Let me note, however, that these sites are at bases with large military and civilian populations. That report also recommended that EPA seek to increase its authority to hasten cleanups by other federal agencies, but no changes have been made to the relevant executive order. Third, the federal government faces significant financial challenges and liabilities associated with hard rock mining operations. From 1997 to 2008, the federal government spent over $2.6 billion to reclaim abandoned hard rock mines on federal, private, and Indian lands, with EPA paying $2.2 billion of this amount. In 2008, GAO estimated that there were at least 33,000 abandoned hard rock mine sites with environmental problems. One factor that contributes to reclamation costs on federal lands disturbed by mining operations is inadequate financial assurances required by the Bureau of Land Management. These assurances are imposed on new mining operations and are used to reclaim a site if the operator fails to adequately do so. In 2012, BLM reported implementing our recommendation to improve the sufficiency of these assurances. Finally, EPA often faces litigation over its regulations and other actions. Companies, interest groups, states, and citizens can sue EPA under CERCLA and other environmental statutes, and these suits can be costly and time-consuming. Such litigation includes citizen suits to compel EPA to take action when it does not meet deadlines, challenges to regulations and permitting decisions, or lawsuits by potentially responsible parties at hazardous waste sites. In 2011, we reviewed litigation associated with 10 environmental statutes and found such cases averaged about 155 per year. The majority of this litigation related to the Clean Air Act. Overall, trade associations and private companies comprised 48% of the litigants, followed by environmental groups at 30%, and non-federal and other parties made up the remainder. Superfund cases represented about 2% of the total cases in our study. This is consistent with our 2009 report on Superfund litigation, which found that litigation had decreased by almost half from fiscal years 1994 through 2007. Regarding the cost of this litigation, we found that the Department of Justice spent about $3.3 million per year defending EPA. Additionally, payments made to the prevailing parties in these cases to cover attorney fees and court costs averaged about $2.1 million per year, with about 3/4 of these payments going to environmental and citizen groups. This completes my statement, and I'd be pleased to respond to any questions.
Thank you, and I'd now like to recognize myself for 5 minutes for initial questions. And just before I go on the prepared questions, Mr. Bearden, I was involved with the, I think you called it the Small Business Liability Relief Act. You mentioned that in the opening statement. That was one of the pieces of legislation that I helped original co-sponsor to get the small businesses, the Main Street stores out of this litigation trap from the potential responsible parties who then would go after, and these folks were de minimis parties to the suit, and it was a great victory, and I think it did help keep the small actors out of the litigation. So thanks for mentioning that. It reminded me. I didn't mention it last week, but I didn't remember the name, couldn't remember the year it passed, all that other stuff. So, Mr. Bearden, can you explain the preference in CERCLA and environmental law generally for non-preemption of state laws, and then tell us if the REDO Act would further that objective?
Well, in general, there is a provision in existing law in CERCLA that doesn't allow or prevent preemption of state laws. And states are free, of course, to enact their own cleanup laws, and many have, sort of a general premise. With respect to the bill, that would specifically address preemption in the circumstance of a financial responsibility requirement. So in that case, when EPA promulgates financial responsibility requirements, in applying those, it would not be allowed to preempt a state requirement that is in place on the effective date.
Would the Federal Facilities Accountability Act also further that objective?
Could you restate the question, please?
Would the Federal Facilities Accountability Act also further that objective?
Oh, the objective of preemption.
Correct.
Well, it expands the waiver of sovereign immunity to apply state substantive and procedural requirements to federal facilities. So it is similar to that objective in terms of allowing state law to apply.
Thank you. In your opinion, are there aspects of CERCLA that could be improved or quote-unquote modernized, in particular the waiver of sovereign immunity? And do the bills the subcommittee is considering today take steps toward making some improvements to the existing statute?
Well, CRS takes no position or opinions about the legislation, but what I could say in response to your question is that what the bills would do are similar in the overall policy vein of the 2002 amendments that would amend the law in ways to be consistent with a greater number of state laws that are in place and to address some longstanding issues about whether waiver of sovereign immunity applies to both current and former federal facilities. And those issues have lingered for a number of years.
So those are possible positive provisions. Are there anything in the legislation that could be positive that we may have left out that could do the same thing and move us forward?
Well, in terms of positive, that, of course, would be a judgment call, and again, CRS would make no position on it, but the types of issues that are addressed in the bills are numerous long-standing issues that have been concerns of the states and other stakeholders about the federal and state roles. So they're not new issues. They are continuing issues that have been addressed by Congress previously in different ways.
Thank you. Mr. Trimble, your testimony states that as a matter of policy, EPA seeks concurrence from state governors or environmental agency heads before proposing a site on the national priorities list. If it is a matter of established EPA policy, do you see a problem with codifying or codifying the policy in the statute?
We've not done specific work on that. I think the questions that would have to be looked at are whether there's specific cases where EPA might still need the authority to list a site over a state objection. And I'm thinking off the top of my head, I'm thinking of issues maybe on sites that sort of cross borders between states, so there could be a dispute between states, or it could be perhaps a situation where the state's somehow responsible for the pollution. But that I'm just.
But you don't know of any particular example that we could cite right now? I understand that concern, but I was just wondering if there's an actual case. CERCLA and the regulations implementing CERCLA already provide the states with limited consulting role before remedy selection. Do you see a problem with amending the statute to codify the regulations and ensure that states are consulted during selection of the remedy?
Again, we are not taking a position on the legislation. We've not done any work on this issue of how effective the state consultation mechanisms are within the Superfund program. I think it's an interesting question, but that's not something that we've delved into in our past body of work.
Yeah, and in testimony last week, it was interesting, the point being there was some desire to be ensured that they have consultation early in the remedy because their complaint was we have the cost at the end. We have the operation and maintenance cost at the end, and so maybe we should have some role in saying how the remedy, or at least give our opinion, because we're going to be on the hook for the longevity of the program.
Yeah, and I think, again, there's, because of the financial requirements for the state to kick in 10% on the remedial costs and also to sign up for the lifetime costs of the operation and maintenance, there is a hook for the state, again, but we have not looked at whether that gives them enough leverage in the process to protect their interests. I think one of the questions that came up last week, and it's to your point, is how effective is the cost-benefit analysis EPA is doing when they're choosing their path forward, and does that bias towards sort of short upfront costs and more higher long-term costs or not? But it's a good question, but it's not something we've looked at.
Great, thank you, Chair. Now I recognize the ranking member of the subcommittee, Mr. Tonko, for 5 minutes.
Thank you. Thank you very much. I thank the Chair for reconvening our hearing today. We may not cover every issue, but as our additional witnesses appear, they help broaden and improve the record. So thank you very much. The hearing last week gave me reservations about the bills under consideration. Not a single witness gave unqualified support to the bills we are examining today. In fact, we heard testimony that one of the bills we are considering would increase litigation and delay the cleanup of contaminated sites. One of the majority's witnesses explained that Superfund now contains a bar on pre-enforcement judicial review. This provision is important because it prevents litigation from delaying needed actions to address releases of hazardous substances that threaten human health and the environment. So, Mr. Bearden, one of the bills we are considering today would reverse this long-standing policy, would it not?
Yes, with respect to states filing objections to the selection of a remedy.
Right. If enacted, a responsible party or anyone else for that matter could go to court and sue EPA before cleanup even begins. Is that correct?
If a state were to file a written objection and someone were to have standing under that provision, yes.
And that would be before the cleanup begins.
The way the provision is worded, the trigger of the timing is when the state files its written objection.
Okay, that litigation could delay then the cleanup of contaminated sites, could it not?
That would have to be demonstrated over time. Whether it would delay it would depend on the nature of the individual suit.
We also received testimony last week that a responsible party could have a financial incentive to go to court, delay a cleanup, and argue for a less protective cleanup remedy. Do you agree with that assessment?
That would involve speculation on what a party may be motivated by, so CRS cannot comment on that. But again, anyone who may have standing under that provision once the state files its objection could at least pursue the matter.
Mm-hmm. Which would affect the time element. The end result could be that judges decide how to clean up Superfund sites, and none of the witnesses last week seemed to think that that would be a good scenario. Mr. Trimble, we've seen the problems with litigation, haven't we? Has litigation been a problem under Superfund in the past?
As we've reported, I think initially there was a heavy amount of litigation. Over time, as courts settled some legal issues and the number of sites being added slowed down, and EPA increased its reliance on sort of agreements out of court, the number of those cases has dramatically gone down. And I think, as I said, right now I believe it's 2 to 5% of all litigation cases that we looked in our list. Not as large as you would think it would be given the universe.
And can you give us a sense of the costs of those litigations?
Yeah, so there's a couple of costs. One is the Department of Justice costs to defend EPA, and the numbers we have are for about 10 environmental statutes, and I believe it was about, I think their costs were about $3 million per year, if I'm remembering correctly, and the payments were about $2 million per year.
Mm-hmm. And what have the recent trends been in Superfund litigation over the recent years?
Well, in our report from a couple years ago, we found that it had decreased, I believe, by over half.
And that's in duration and in cost, or?
That was just number of cases.
Okay. And can you speak to the complexity of those cases?
No, I don't have any information on the complexity in terms of the trends of those.
Mm-hmm. Well, that certainly is a positive trend, but I'm concerned that it could be reversed by lifting the bar on pre-enforcement judicial review. Is that a legitimate concern in your opinion? Well,
again, we don't opine on the pending bills, but clearly as sort of the rules of the road have settled, the litigations has declined over time in the program.
Mm-hmm. Mr. Chair, I hope we can give this the bipartisan attention it deserves. No one, in my opinion, would be well served if we end up moving legislation that increases litigation and therefore would cause delays in the cleanup of contaminated sites, which would then really speak to the overall mission statement and soulfulness of the legislation. So with that, Mr. Chair, I yield back.
And the gentleman yields back a time, and I want to assure him that as conservative Republicans, additional litigation is something that we are not interested in. So I think there's some language that could be added to ensure that that does not happen. Chair now recognizes the gentleman from Ohio, Mr. Lauder, for 5 minutes.
Thank you, Mr. Chairman. And gentlemen, thanks very much for your testimony today. Mr. Trimble, if I could start my questions with you. In the 1990s, GAO reported that within the EPA's cleanup budget for CERCLA, less than 50 cents of the dollar was spent on dirt moving cleanup versus oversight and administrative costs. Is that still the case?
We have not done recent work on taking apart their costs at this for the recent cleanup. So I'm not sure what the ratio was. I know there's a lot of work, I'm sure still even today, in terms of doing site investigation and assessment. So as opposed to sort of final construction activity.
Well, I guess when you say that you haven't really been able to take it apart, is there a way that you could get a current amount?
We
Back to
could, I
committee?
mean, it's not something we'd readily have. We'd have to do a review on that.
Yeah, if you
kind of thing we
could,
could do.
if you could provide that, I think the committee would like to know what that ratio is now, because we're still at that 50-50, because I know of sites out there that really need cleaned up, and at 50 cents on the dollar, that's not helping those sites. If I could go on then, if we could get that. It seems also that many states have developed constructive working relations with the Department of Defense, particularly utilizing the Defense State Memorandum of Agreement. Are you familiar with the general working relationship between other federal land managers and states on non-MPL sites?
I think we've done some work. I'm personally not that familiar with it. I know we've had done work on the cleanup of mines, so the relationship with the EPA and BLM, for example, and we've done work in that area.
Let me ask this. Is there a distinction between the relationship between DOD and DOE may have with the states versus the federal land managers, for example?
I'm not familiar with again, we've not looked into the relationship between states and DOD or states and EPA for that matter. Regarding DOD, we've reported on difficulties where DOD has refused to sign interagency agreements with EPA governing this cleanup of NPL sites.
You say that DOD has not signed. Is there a reason for that?
Not that we can understand. This is an ongoing issue. In our report from a couple years ago, we had identified 11 sites where they had refused to sign the agreement, which is required under CERCLA. After our report, they took action, and now there are only 2 sites. One of these is Tyndall Air Force Base. And even in that situation with Tyndall, EPA has issued a RCRA order, which DOD has also not complied with. So there's still letters going back and forth regarding this matter. Regarding the RCRA matter, DOD objected to EPA issuing the order. DOJ upheld the EPA's authority to issue it, and we don't have any ongoing work on this. We're just following the issue because it's something we've done work in the past on. But it's a significant issue in terms of hampering the ability of EPA to oversee the effective cleanup.
Okay, thank you. Mr. Bearden, if I could ask you quickly, can you explain the state cost share requirement under CERCLA and maybe give us some insight regarding why states are concerned with EPA selecting the remedies that focus on short-term containment rather than long-term stewardship?
The federal state cost sharing proportion is, as outlined in my prepared statement, is generally 90% share of the federal government for the capital cost of the remedial action, 10% shared by the state, and this, again, 100% of operation and maintenance with the exception of treatment of groundwater. So for containment methods, that may be a concern for the state in terms of being responsible for 100% of the long-term operation and maintenance. For example, if there's a waste cap that has to be maintained for many years, if not decades, the state would be fully responsible for those costs under existing law.
Well, let me just follow up with that. Would a change in the cost share provision in CERCLA address these state concerns?
If the cost share provision were changed to have the state bear less than 100%, then that would increase the necessity for federal resources, and then it may affect decisions that are made. The requirement in existing law is for EPA to consider short and long-term cost effectiveness in assessing the remedy, so there's a statutory requirement to consider cost effectiveness.
Okay. And could you also explain how the criteria for selecting a remedial action may be relevant, and would they also need to be addressed?
I'm not sure I understand your question, sir.
Well, and explain the criteria for selecting remedial action.
The criteria for selecting a remedial action under existing law are that there be applicable, relevant, and appropriate requirements. There are a whole host of criteria in statute and regulation on determining what's applicable, relevant, or appropriate at a site. Generally, a state requirement can be applied as well if it's more stringent than the federal requirement. But then again, those criteria may allow for exclusions of some standards under those criteria.
Okay, and just briefly, if I may, Mr. Chairman, I see my time's expired, but would those also need to be addressed, do you think, those remedial actions, if we're looking at that? Should those actions be addressed out there?
Well, if one is looking at the federal state roles in making those decisions, and one is concerned about who's sharing the cost, one would need to consider the existing criteria under which those decisions would be made.
Okay, thank you. Mr. Chairman, my time's expired and I yield back. Thank you very much.
Gentleman yields back his time. Chair now recognizes the Chairman Emeritus of the committee, Mr. Dingle, for 5 minutes.
Mr. Chairman, I thank you for your courtesy and I commend you for holding this hearing. I want to begin by congratulations to Mr. Bearden and Mr. Trimble. You have given good testimony this morning, and your agencies have been agencies that this committee has looked to most urgently for your help in times past as well as today. These questions are for Mr. Trimble, and I'm hopeful that to the degree you can, you will answer yes or no. Relating to the amendments to Section 108 of CERCLA, can you tell the subcommittee how many states have promulgated financial responsibility requirements?
I do not know the answer.
Could you check and submit that?
I can check to
us,
see if we
please?
have that.
And perhaps you would want to make a comment on that, Mr. Trimble, but I assume you'll want to do that for the record. Now, or rather, Mr. Bearden, what are the amounts set in each state and for what classes of facilities? I assume that's a matter that you'll have to submit for the record also. Now, the next question. Does anything prevent a state from obtaining funding from fees, taxes, or other sources of revenue to clean up toxic waste sites in the respective states and thus have total control over the remedy selected or removal action taken? Yes or no? This to Mr. Tripp.
Not to my knowledge.
What does that mean? No. Next question, if you please, Mr. Trimble. Section 113H provides new opportunity for lawsuits where a state simply writes a letter objecting to a remedy selected by the President. After such a letter is posted by the state, would this new provision also allow the responsible party who polluted the site in the first place to litigate and to challenge the remedy? Yes or no?
I'm not a lawyer, but I would think it would.
You would think it would. Do you have a comment on that, Mr. Bearden?
I addressed that question, a similar question earlier. Assuming someone would have standing under that provision, the trigger would be, as you mentioned, the state filing a written objection to the selection of the remedy.
Thank you. Now, this to Mr. Trimble. Mr. Trimble, would this provision allow an environmental group to also challenge the remedy if they could get a state to write such a letter? Yes or no?
Yes.
And I would assume that almost anybody who could involve themselves in this could enter the litigation of the question, could they not?
I would defer to Mr. Bearden, but
Mr. Bearden? Oh, go ahead. No, please, Mr. Trimble.
I would assume so. But again, we've not done audit work in this area, but my understanding would be that's the case.
Mr. Bearden?
As with any litigation, it would depend on whether someone has standing, and a judge would have to decide that based on the circumstances and
Of
merits.
course, we would significantly increase the number of persons who have standing by this provision, would we not?
It does broaden the opportunity for judicial review.
Now, what happens to the citizens and the surrounding community that is being exposed to the hazardous substance and hazardous conditions, or to communities or persons in the communities who wish the site to be redeveloped to create jobs while the remedy decision is litigated in the federal courts? They just got to sit and grind their teeth, don't they? Yes or no?
I don't know about the grinding of the teeth, but
I know if I were, I would. This has then a significant chance of increasing the number of litigants and the amount of time that is involved in concluding the cleanup of these sites, does it not?
I would suspect that the delay would add the time, yes.
All right. Mr. Chairman, as I stated last Friday, I do not see the factual record in this matter justifying significant changes to the existing law here. The changes to Section 113H, expanding the opportunities for litigation, meaning communities would have to live longer without a cleanup remedy. Section 121F of current law already details requirements for substantial and meaningful involvement by each state in initiation, development, and selection of remedial actions. Then there's an amendment in an amendment to Section 108. In this section, the Congress wanted EPA to establish financial responsibility requirements for various classes of facilities so that they could maintain evidence of financial responsibility consistent with the degree and the duration of the risk associated with the production, transportation, treatment, storage, or disposal of hazardous substances. The agency has been dilatory in implementing this provision. However, instead of calling EPA to task for failing to act, the legislation here seems to have a goal to eliminate the one provision that was imposing a mandatory duty on EPA to initiate the action. I feel with regret that the amendments appear to be solutions in search of a problem, and I hope that as we continue our discussion of these matters and our evaluation of these matters, it will be possible to address the concerns that I have expressed, and I thank you for letting me run over time.
And I thank the gentleman. Chair now recognizes the Vice Chairman of the Subcommittee, Mr. Gingrey, for 5 minutes.
I thank the Chairman for yielding, and Mr. Trimble, I'll address my first question to you. In an October 2009 report on formerly used defense sites, I think that's GAO Report 1046, GAO found that the Army Corps has not consistently conducted CERCLA 5-year reviews to ensure continued protectiveness of remedies on sites where the chosen remedy does not allow for unrestricted use and unrestricted exposure. So, did GAO find that the Corps routinely complies with state land use control and environmental covenant requirements for such sites?
I do not recall on the, from that report if it got into the details of where there was noncompliance, if it was specific to state-specific requirements. The finding was if you go through remedial action and you clean up a site and you say your construction complete and you're just in the operation and maintenance phase, at that point you have to watch it, monitor it every 5 years to make sure it's still in a good shape. What that review found was that for the formerly used defense sites, the Army Corps was not doing a good job at monitoring those sites to make sure that everything was still as it should be, or if new contamination had emerged or new remedies would have to be put in place. Now, the basis for how it could have gone off the rails might have been state requirements versus federal requirements, and I don't know off the top of my head if that report got into that level of detail.
Would that be true for commercial sites as well, or not, or just formal?
Well, the 5-year requirement would be there, but who would be doing it would be different.
Yeah, but the 5-year requirement is there is also. Mr. Bearden, we also understand that there are EPA regulations pertaining to consultations with the states regarding remedy selection. And we understand that the statute already requires consultation at certain points in the process. Do you think that codifying that regulatory practice in statute would be a bad thing?
Well, there are many instances where Congress chooses to codify a regulatory requirement to elevate it in statute, and that's a policy decision of the Congress.
Well, wouldn't codifying the regulations regarding consultation, regarding remedy selection, ensure consistency among all the EPA regions and ensure that other federal agencies also consult with states when selecting a remedy?
Well, the regulatory requirements already apply to all regions and to other federal agencies who implement the National Contingency Plan, which are the regulations to which you're referring. Whether in practice they implement them consistently may be a question, but they already are required to follow those regulations. as are the...
Well, the question was, wouldn't codifying the regulations make this work better and more consistently?
Again, it would elevate it as a statutory requirement, but it already is a requirement. There may be questions of application on a consistent basis.
Well, that's my whole point. CERCLA specifically requires consultation with the states before selecting a remedy. The Federal-State Partnership for Environmental Protection Act would amend the timing of the consultation to ensure that states are consulted during the process of selecting a remedy. What is your opinion about changing the timing for the consultation?
Well, CRS would take no opinion on any amendments, but in terms of timing, that difference would be in current law, it's in determining the remedy, and that may be interpreted as the point at which you're selecting, as opposed to earlier in the process before a determination is made. So the bill would expand the time frame to an earlier stage of the process in statute.
Mr. Chairman, I see I've got about 45 seconds. If anyone on this side, or you want me to yield back to you? Or
Just yield back.
I'll yield back, Mr. Chairman.
Gentleman yields back. Chair now recognizes the gentleman from California, Ms. McNerney, for 5 minutes.
Thank you, Mr. Chairman, for holding this follow-up hearing. Mr. Bearden, in your testimony, you stated that the states have input into the designation of the NPLs. Can the EPA list sites on the NPLs without state concurrence or cooperation?
They have the statutory authority, EPA has the statutory authority to list a site without state concurrence. I don't know of an example in which that has occurred. The amendments in 2002 addressed that very issue that limited EPA's authority to list a state, to list the site without the state's concurrence. A state may request EPA to defer, and there would have to be a set of conditions that EPA would determine that a state was not making adequate progress toward the cleanup in order to list the site despite a state's request to defer the listing. So it's more limited in current law as a result of the 2002 amendments.
Well, last week we heard from state organizations who claim to have little or no input into the process. Could you explain the disconnect?
Well, I can't speak as to their level of understanding, but if one reads Section 105H of CERCLA, which was added again in the 2002 amendments, a state merely has to request that EPA not list a site, and at that point, that limits EPA's authority, again, unless a determination is made under the statutory criteria that listing is necessary to protect human health and the environment.
Okay, yeah, there's a disconnect there, clearly. You said that the Federal Facility Accountability Act of 2013 would hold federal agencies more accountable at federal facilities to include current and former federal facilities to encompass the entire phase of the cleanup process and to clarify in greater detail the extent to which substantive and procedural cleanup requirements of state law apply to federal facilities. Can you explain the impact that this would have on listing of NPLs?
Well, it would not have a direct bearing on the listing of sites on the national priorities list. It would determine, based on the language in the bill, it would apply to either national priorities list sites or non-national priorities list sites. It would determine what requirements that are substantive and procedural to the state may be applied to the cleanup. It would determine how the cleanup may be performed and apply regardless of the listing status.
Thank you. Mr. Trimble, in your testimony you stated that CERCLA authorizes the EPA to compel potentially responsible parties to clean up their sites. Do you think that the proposed bills will undermine the EPA's authority in this compelling the potentially responsible parties to clean up their sites?
Yeah, I don't know if I have any work that would speak directly to that, and I think you'd have to see how these things sort of were implemented. I think the issues of if there's the EPA is restricted and take immediate sort of response actions, that could be one issue that could come up. So I'm not sure I have much more to offer than that on that question.
Well, the authority for funding the actual cleanup expired 18 years ago, despite the increasing financial liability since that time. Rather than trying to restructure the authority in CERCLA, Congress should, in my opinion, reinstate the fees on which the old funds relied. Are there other funding sources that would be viable to supplement the fund?
GAO has not taken a position or looked at alternative funding issues. Clearly, the Superfund, the tax was one option. Right now, it's coming out of general taxes, general fund. We have done work looking at sort of anticipated future costs in the Superfund program, and those costs are very difficult to measure for a variety of reasons. Superfund program managers have estimated that their costs will likely exceed available monies going forward as many of these sites get more complex and complicated, for example, some of the mining sites. But we don't have an opinion on, it's more of a policy question in terms of where the money comes from, so we don't have a position on that.
But there is going to be a critical shortage of funds from all sources to clean up these sites.
Well, the program will continue to need a lot of money going forward.
Okay, thank you. I yield back, Mr. Chairman.
Gentleman yields back his time. Chair now recognizes gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, for the time, and gentlemen, thank you both for being here with us today. Mr. Trimble, has your office ever conducted a review of other federal agencies' implementation of institutional controls as a part of removal or remedial actions conducted pursuant to authorities granted under CERCLA or Executive Order 12580?
To my knowledge, we haven't. I mean, I can certainly check when I go back, but I'm not familiar with prior work on that issue. It's a good
Would you
issue.
please check and get
Absolutely.
back with us? I'd appreciate that. Do you think it would be constructive to conduct such a review?
Absolutely.
Okay. Let me go to also to you, Mr. Trimble. In June of 2006, GAO conducted a review of EPA's implementation of institutional controls by the EPA Superfund program. In this or any subsequent review, were you able to ascertain whether EPA routinely complies or requires compliance with state land use control or environmental covenant laws and regulations?
And I apologize, I'm not familiar with that report, and I would love to take that for the record if I could.
Okay, good. I'd appreciate that as well. Would it be fair to anticipate that requiring federal agencies, in your mind, would it be fair to anticipate that requiring federal agencies to comply with state laws which require that institutional controls be implemented and enforced in perpetuity, that this would help ensure that these controls are in fact maintained for as long as they are necessary to protect human health and the environment?
Yeah, I'm curious on the work we've done in the past, because I think the key question is whether or not they are currently considered in the existing procedures and processes, whether or not there's a disconnect between the state's desires to apply certain controls and whether those are actually going on into effect, and whether or not they have enough leverage to make that happen. If there's a breakdown there, then certainly there's an issue to be looked at.
Okay. Well, thank you. If you would get back to the committee on that, I'd appreciate it. Mr. Chairman, with that, I'll yield back my time.
Gentleman yields back his time. Chair now recognizes the gentlelady from California, Ms. Capps, for 5 minutes. Take your time.
Leaching from contaminated sites. The bills before us may affect many aspects of the program's ability to accomplish this goal, but my time is limited, so I want to focus on one particular provision. My first question is going to be for you, Mr. Bearden. The federal and state partnership bill we are examining includes an amendment that could complicate and impede, in my opinion, the streamlined process currently in place for short-term Superfund removal actions. So I wanted to ask you, Mr. Bearden, can you explain what removal actions are and why we need to be able to undertake them quickly?
Removal actions can be conducted in two different capacities. One is referred to programmatically as time critical. The other is non-time critical. At any site where a release is reported and EPA, state and local officials become aware of it, the very earliest actions to stabilize the site, may be considered in practical terms to be the early emergency phase of the response, but the removal action can continue much longer than that, especially the non-time critical removal action. So there are various phases even for the removal aspect of the process.
So some removal actions are very pressing and are needed to address imminent public health threats. And I mean, that could be the trigger that necessitates the quick action. Am I right?
Correct, that the initial response is a removal, and the very earliest stage of the response is to stabilize the site and prevent potentially harmful exposures at the very earliest stages.
Okay, moving on, these imminent threats are why these actions have always been done in a streamlined process. In testimony they provided last week, the EPA expressed concern that this legislation as currently drafted would require consultation before removal actions could even begin. The agency said the bill could, and this is a quote from EPA, the bill could have an adverse impact on our emergency removal program by introducing potential delays when EPA needs to conduct time-critical emergency removal actions, end quote. Having a Superfund site in my district, this is really a big concern for me, the timing that we're talking about. So, Mr. Bearden, do you agree with EPA's assessment that this procedural change has a potential to delay removal actions?
Well, CRS would not agree or disagree with an agency position, but what I can say is at the very earliest stages of the emergency response, even under the regulations of the National Contingency Plan that EPA promulgated, state and local officials are expected in most cases to be the first responders. So it's actually the state and local officials who are on site. Most often it's the local fire department, local police department to stabilize the emergency conditions, and then it becomes elevated to EPA's attention.
And that would, your careful delineation of those steps indicates that the reason they're done that way is to enable prompt response and timely response. Okay,
yes.
I have only one question left, but I want to make sure that I ask you, Mr. Trimble. The GAO has done work on contamination at Superfund sites nationwide and on health assessments of Superfund sites done by the Agency for Toxic Substance and Disease Registry. These assessments find risks of cancer, developmental issues, neurological effects. So my question to you, Mr. Trimble, what could be the consequences of delaying emergency removal actions?
Assuming the delay actually resulted in increased exposure to whatever contaminants, then the problems being cited by a TSDR could be expected to be greater.
So you two are sort of in agreement with the notion that if if something is discovered, that the local responders really are in a position, because they're close, to make that initial assessment. Doesn't remove EPA's responsibility, but it allows the emergency response to happen the way emergency responders are trained to do, and then they come in and make an assessment when there's a little more time in their favor. Would you agree? Any other comments you wish to make on either of these points, either of you?
No.
Then I'll yield back the balance of my time.
Gentlelady yields back her time. Chair now recognizes the gentleman from Florida, Mr. Bill Rockus, for 5 minutes.
Thank you. I appreciate it, Mr. Chairman. Mr. Bearden, what recourse do states currently have if they disagree with EPA decision or remedy, and what recourse do states have if they disagree with another federal agency's decision or remedy?
The current existing mechanisms, if it's a site that will be funded with federal Superfund appropriations for the remedial action, since the state is responsible for sharing the cost, as I outlined in my prepared statement, if the state chooses not to provide those matching funds under existing law in CERCLA, EPA does not have the authority to use the federal Superfund appropriations. So that is some leverage that the state could be provided, and that's the underlying intent of the way the matching funds requirements are structured, to have a factor be included in the federal decision on whether or not the state agrees to provide its match. So those, again, are circumstances where federal Superfund appropriations are used. So that would not apply to sites where private, potentially responsible party funds are used through enforcement actions. In those cases, then the state input is limited to the consultation process under existing law. In terms of federal facilities, As was mentioned earlier, there is a provision in existing law for states to challenge the selection of a remedial action in a U.S. district court, and as outlined in my statement. So that is a mechanism specifically at federal facilities where it would be administered and funded by other federal agencies like Department of Defense and Department of Energy.
Thank you. Mr. Trimble, during the first day of this hearing, the subcommittee heard testimony comparing the compliance rate of federal facilities under the Clean Water Act and the RCRA. The testimony indicated that due to the ability of the states to impose and collect penalties under RCRA, but not under the Clean Water Act, that RCRA experiences a significant higher compliance rate by federal facilities than does the Clean Water Act. Has GAO ever conducted a similar evaluation? And if so, what did you find?
Again, to my knowledge, we've not done such a study. I'm happy again to look to make sure I'm not missing something when I say that. I think in general, the issue of having a stick to ensure compliance makes people behave better. As I noted earlier, in our we have made recommendations in terms of EPA's ability to make other federal agencies comply. I think with the issue of DOD's compliance with the requirement that they sign an interagency agreement with the EPA governing the cleanup at 2 NPL sites, Tyndall Air Force Base in particular comes to mind. And we've made GAO's made recommendations in the past as a matter of congressional consideration that to give EPA more authority to force compliance by DOD when they're faced with these kind of situations. Okay,
one more question, Mr. Chairman. Mr. Trimble, in your testimony, you mentioned Executive Order 12580. Does this executive order enable some or all federal agencies, including those that are potentially responsible parties, to self-regulate and make determinations regarding their compliance with state and federal cleanup requirements? And if you can please explain, I appreciate that.
Yeah, and I will probably lean on David to help me out here.
Okay,
but
that'd be
I think
great,
it gives agencies like DOE and DOD the authority to manage the cleanups. EPA is still in the sort of a partner position, but also to provide independent oversight on those activities to make sure the cleanups are done appropriately, which is, again, speaks to the need for that interagency agreement at places like Tyndall to make sure they're being done appropriately on time and to the correct standards. But
yes, please.
Yes, all I would add to that is when it's a federal agency like Department of Defense, Department of Energy, there can be other federal agencies as well. The executive order that you cited authorizes that agency to execute the president's authority for the response action, which is carrying out the cleanup itself. But when it's a national priorities list site in a federal facility, as Mr. Trimble mentioned, EPA has a prominent oversight role and actually under existing law has final decision-making authority at the federal level for selecting the cleanup actions, and the deference is to EPA, not the federal agency responsible for carrying out the cleanup. And in terms of state involvement, if it's a non-national priorities list site, the state primarily is responsible for overseeing that cleanup carried out with the president's delegated authorities under the executive order.
Thank you. I yield back, Mr. Chairman.
Gentleman yields back his time. Chair now recognizes the gentleman from Pennsylvania, Mr. Pitts, for 5 minutes.
Thank you, Mr. Chairman. I just had a couple questions. Sorry to be in and out with meetings. Apologize if this has been asked. But, Mr. Bearden, we understand that it is currently EPA's policy not to list a site on the national priorities list over the objection of the state. Do you think that codifying the EPA policy in the statute would ensure that states could count on this policy?
Well, codifying it in statute and making it binding by law would certainly require EPA to adhere to that policy.
Wouldn't codifying the policy to not list a site on the national priorities list eliminate any potential inconsistency among the regions?
Yes, there would not be any discretion in implementing the existing policy if it were to become a uniform statutory requirement in all cases.
Now, do you have any comments or opinions regarding whether it would be beneficial to authorize EPA to review actions taken by other federal agencies under CERCLA to ensure consistency with EPA cleanup guidelines, rules, and regulations?
Well, under existing law, when it's a federal facilities on the national priorities list, already EPA has the authority under the interagency agreement to make the decision on the final remedy selection. So there already is that mechanism for ultimate review and making a decision.
If I could add to that, what's missing, though, is giving EPA a stick if they find noncompliance. So I believe the way the language is written, it allows EPA to review, but what happens if EPA finds somebody is in noncompliance? And that's sort of the situation we have today.
Thank you, Mr. Chairman.
Gentleman yields back his time. The chair wants to ask unanimous consent for a couple letters to be submitted in the record. One letter from public interest groups on RCRA Section 202B and Circular 108B. A letter from other public interest groups on Circular Section 113H and Section 105. And a letter from Headwaters Resources, also signed by Boral Material Technologies. They were referred to in the first testimony, and I quote a line in here: Headwaters and Boral utilized Section 202B of RCRA in an attempt to end the recent uncertainty as a matter of overall governance. We think Section 202B of RCRA makes for poor public policy. It could enable special interest groups through deadline suits to set EPA's agenda. So we submit those into record. Now I'm joined by a colleague from Texas, Mr. Green. You're recognized for 5 minutes.
Thank you, Mr. Chairman. I apologize to our witnesses. We're balancing two committees at the same time, and I just finished in O&I committee. I want to thank you for holding a hearing today. I'm happy to see GAO and CRS come before our subcommittee to speak on proposals to amend CERCLA and RCRA. I have a very urban district in Houston, and it's East Harris County, which is heavy industrial, largest petrochemical complex in the country. And there are a number of Superfund sites in and near our district that I've been involved with over the years. The most recent one, although it's been there a while, including the U.S. Oil Recovery Site in Pasadena, which was added to the National Priorities List last year. From my experience, the Superfund program has played a valuable role in protecting the environment and human health of my constituents and for Americans for all 50 states, and I'm concerned how the proposed legislation would change this program. Mr. Bilden, is it true that the EPA is already obligated by federal statute to give substantial deference to the states on naming sites in the NPL?
The substantial deference is a result of the 2002 amendments. EPA may still list a site if EPA determines it's necessary to protect human health and the environment, but generally defer to the state if they desire not to list the site.
Well, the two I've been involved in, we concurrence from the state agency. In fact, the state agency was very happy to have them listed on the site, and including the current one. But Mr. Bearden, is it true that the 2000 amendment to limit EPA's enforcement authorities to CERCLA to pursue the cleanup of a site if a state is already pursuing the cleanup under its own law?
Yes, the 2002 amendments address that issue.
You know, again, my experience with Texas is that we've had good cooperation between our regional office on our Superfund sites. I wish we didn't have them, but again, in an industrial area, that's going to happen if you've been producing, you know, chemicals and things for 60, 70 years. Mr. Bearden or Mr. Trimble, in your knowledge, has a site ever been added to the NPL without the concurrence of the governor of state in which the site is located?
I'm not aware of one myself.
I am not either.
Mr. Trimble, in your testimony, you know that over 40,000 potential hazardous release sites have been reported to EPA over the past 30 years, and yet EPA has only determined only a few thousand of those sites for NPL designation. Is that true?
That's correct.
What happens to those sites that are reported to EPA and not added to the NPL?
They are generally cleaned up under other cleanup authorities. So in our most recent report, we note that sites that are assessed at a level where the contamination would make them eligible for Superfund, so they're severely contaminated sites, the majority of those sites actually are not handled by the Superfund program, but are cleaned up under other cleanup authorities, principally managed by the states. The states manage about 47% of all those sites.
So the states handle about, so some of the sites are deferred to the states, and so that's about 47% of them?
Yeah, the majority, the states handle more Superfund caliber sites than EPA does under the Superfund program.
You know, in my experience, though, I haven't had the state being one to take it over because it's always been the EPA oversight on, and cleaning up. Our problem is making sure we go do the due diligence and find a responsible party. Otherwise, it's going to be the taxpayer ultimately does it, which makes it harder, Mr. Chairman, when we don't have budget appropriations for that. That's why responsible parties are really important. You stated in your testimony the number of NPL site designations has increased in recent years. Is that true?
That's correct. I believe it's running about 22 a year.
Okay. And again, a few years ago in Congressman Ted Poe's district, we were Borders. It's a dioxin facility that actually submerged back in the 60s, and nobody knew about it. But we always knew that the Port of Houston had higher dioxin levels, but my industry that was there were being blamed for it, and yet it was from an old site that very quickly Congressman Poe and I worked with EPA to be able to put it on the NPL list. So that was a very bipartisan effort, and again, the state was happy that that we finally were able to find where that the source of that. We still have a cleanup problem. It's encapsulated. But how do you deal with sediment in a river that's 40 years old? Can you explain the number of designations has increased and why the number of designations increased in recent years?
A couple of factors that we've been discussed in our reports. One is it's often linked to sites or states' abilities to take on these sites. So with the economic downturn the last few years, the state's ability or willingness to take on the cleanup responsibilities for these has gone down, which means the burden gets shifted to the federal government. And then also just there's some emergence, and then a growing number of these sites are abandoned mine sites that have come on over.
Okay. Thank you, Mr. Chairman, for having a hearing.
Chairman, so gentleman's time's expired. Chair now recognizes ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. I thank you for reconvening the hearing today, and I'm pleased that we have the opportunity to hear from knowledgeable experts about the Superfund program. The legislation before us has been presented as correcting a problem where states are not sufficiently consulted in the decisions to clean up contaminated sites through the Superfund program. The argument is that although Superfund is a federal program carried out by federal employees using federal resources, a state should be able to slate sites for cleanup, veto sites from being slated for cleanup, have a greater say in cleanup decisions, and even collect their attorney fees from the U.S. taxpayer when they sue the federal government. I'm not sure this approach strikes the right balance. Mr. Trimble, if a state wants more control over the cleanup of a contaminated site, the state can simply conduct its own cleanup under state law and retain full control of all decisions. Isn't that right?
That is correct.
And in fact, this happens regularly, doesn't it?
Yes, it does. About 47% or 48% of all Superfund caliber sites are managed by the states.
The states don't always do that, though, because they want federal resources and expertise brought to bear to get sites cleaned up. Isn't that correct?
That's correct.
In fact, the states often request that EPA come in and conduct expensive removal actions and response actions, don't they?
Yes.
Federal government pays the entire cost of a removal action. The states pay just 10% of the cost of a response action. The rest is picked up by the federal government. Is that correct?
I believe that's true for remedial actions. I'm not sure about removal.
Okay. And there's a great variation among the states in their capacity and resources to carry out site cleanups, isn't there? Some are better at it than others.
Yeah, absolutely.
Even though Superfund is a federal program, the law provides for significant state involvement. Under the statute as it currently stands, EPA is required to provide, quote, substantial and meaningful participation, end quote, to states. Mr. Trimble, under current law, are states involved in suggesting sites for cleanup under Superfund?
They are, yes, in terms of reporting sites with contamination, and then EPA has a consultative process.
So they can propose sites and have the ability to directly list one site on the national priority list. Isn't that the case?
I would defer to Mr. Bearden on a more thorough answer on that, but I don't think they have the authority to list. I mean, I wouldn't go quite that far.
Okay, well, let me continue with my questioning for you. Under current law, EPA seeks concurrence from states before slating a site for cleanup on the national priority list. Is that correct?
Correct. Under policy, correct.
Okay. Under current law, states can block EPA from carrying out a selected response action by not agreeing to pay the cost share for that response action. Isn't that right?
Yeah, EPA could not use funds to clean that site up under the Superfund program without state concurrence.
Finally, Mr. Trimble, if a state wants to take a leadership role at a Superfund site under current law, they can assume the lead under cooperative agreements with EPA. Isn't that correct?
That's correct.
I thank you. It's natural that a state would want to be able to tell EPA what to focus on and what to spend money on and what not to spend money on. It's natural that a state would want federal resources available for use at their discretion. But this is a national program that must be available to clean up the most contaminated sites in every state. It's our job to ensure a balanced approach. Mr. Chairman, I have serious concerns about certain aspects of these bills. I think they are a work in progress, and if you're interested in moving these bills, I urge you to convene a process that will allow us to examine whether there are problems here that need to be addressed and how to address them. I thank the witnesses, and I hope the chairman will consult with us on some of these ideas.
Gentleman yields back his time, and just to address the ranking member, we've already had some staff-to-staff attempts to talk about. I think that this is a legislative hearing. I think there's two issues raised that on some of the provisions that would be helpful to get input and maybe move forward. And we'll let our staff give that a try first, and if members want to be engaged, they know where to find me. So with that, we want to thank our folks. So we want to thank our second panel for coming. This is a legislative hearing, which is for us to gather input, which we have done today with your help and your expertise. We thank you, and with that, the hearing is now adjourned.
It's good to see you again.
Good to see you. Great job. I'm glad bailing me out on all those questions. I appreciate it.
It's a team effort. We're sister agencies. That's what we do. So it's good to see you, Elizabeth.